Hello. In today's presentation, we'll be looking at tort liability for nervous shock or psychiatric illness. Imagine yourself walking to school or going out for an event, and on the way you witness an exceptionally traumatic accident that involved third parties. Perhaps you even participate in the rescue operation, or just you stood by and watched and saw the agony of human suffering. Or perhaps you were watching your news on television and they suddenly present to you the video of an accident, maybe a train accident, a helicopter crash, or whatever kind of accident, and you are able to see the effect on the victims, and you, as a result of that, you felt extremely traumatized to the extent that you suffer a recognizable psychiatric illness or what we call nervous shock. Imagine also in these scenarios that perhaps you are even in your house and someone tells you that there has been a plane crash and that the plane was en route to a particular destination, and you realize immediately that a loved one was on that plane, and the effect could be better imagined. These are some of the case scenarios that have come before the law courts in terms of determining tort liability for nervous shock or psychiatric illness premised on the thought of negligence. So in today's presentation, we'll be looking at how the law has formulated a duty of care in a situation where there's liability for, where there is a claim that someone has suffered what we call nervous shock or psychiatric illness, recognizable psychiatric illness, as a result of an event that has taken place. And for the purpose of this presentation, therefore, we have as a learning outcome the need to look at the evolution of liability for nervous shock or psychiatric illness. And to do that, we'll also be able to situate the current state of liability. What is the current state of liability for nervous shock or liability for psychiatric illness? And would also hopefully be able to understand the premise upon which the law would hold you liable. What are the things that a litigant, a plaintiff, must be able to explore to show that the elements, so to say, that there is a duty of care in the kinds of case scenarios that I had presented to you. So if we're doing that, I hope that you understand the format of our presentation by now, that we'll look at the basic principles that the law has developed and then mention a few cases to illustrate our points. While we expect that you are able to go ahead and read most of your cases in detail at the end of the presentation. So you have your learning outcomes there. Understand the meaning of nervous shock, or liability for nervous shock in the thought of negligence. I appreciate the historical reluctance of limitation, because I will demonstrate to you that the courts were initially reluctant to impose liability where there has been a negligent action that has caused psychiatric illness or nervous shock. Understand the current scope of liability for nervous shock in the thought of negligence, and apply the rules of liability for nervous shock. We have to make some clarifications. In the example that I have given to you, for instance, you were on the road, you're on the way to an event and you witnessed an exceptionally traumatic accident where people were injured, maybe some died, some had broken arms and legs and what have you. Perhaps some of you even participated in the rescue. And as a result of what you had witnessed, you are suffering from some recognizable psychiatric illness or nervous shock. We are not looking at personal injury now. The person that we are talking about, perhaps the person is even some of the parties that were some of the victims of the accident who have suffered physical injury as well as psychiatric injury. Or maybe the person did not even suffer, maybe the accident almost happened, or, there are different premises and case scenarios that we'll be looking at. But nervous shock, let's clear for clarify our concept. We are talking about injury arising from the infliction of physical injury or fear or risk of physical injury upon oneself or another person. The plaintiff that is before the court has suffered an injury that arises from the fact that the person has suffered a physical injury, maybe somebody was knocked down, and as a result of that, they begin to suffer PTSD, post-traumatic stress disorder, or fear of or risk of physical injury. The injury did not take place. A vehicle almost ran the person down out of the fear and the anxiety that this is going to take place. Maybe the person maybe a woman just has a miscarriage, or the person just has a stroke. It was not physically injured by the vehicle, but they have suffered some other form of injury to their person that we call nervous shock or psychiatric injury. So it can also be as a result of the one that you have witnessed regarding a third party. It didn't happen to you, the litigant, but to a third party. And it's usually must be caused by a sufficiently traumatic event, a sufficient traumatic event. And if it is caused by that kind of event, it's not just that something just witness something. It must be something that is traumatic, shocking event. It must be, then the injury we are talking about must be a recognizable psychiatric illness, not something that cannot be diagnosed medically. It must be recognizable by the fact that we want to eliminate pretensions. We want to eliminate things that cannot be really evaluated in the law. So examples are before you: morbid disorder, hysterical personality disorder, pathological grief disorder, chronic fatigue syndrome, sometimes stroke, miscarriage, heart attack. These are some of the components that have been held to be recognizable psychiatric illness or nervous shock. So you can see that we are not talking about necessarily the typical mental case that you would want to conjecture when you talk about psychiatric illness, but it excludes ordinary stress. You are just upset, or ordinary grief and anxiety that people may experience. Then we'll be looking at what we call primary victims. When you have this kind of case scenarios, like for instance, like I said, you're on the way to an event and you just witnessed this exceptionally traumatic accident or incident, or a train crash, or an airplane helicopter crash, or any kind of event that we are talking about. The people that we are talking that usually come to court have been broken into two categories. You have who we call the primary victim and the secondary victim. A primary victim is someone who is within the range of foreseeable physical injury. For instance, the train that crashed, maybe the person those who were in the train, those who were on the rail line, someone that was within the range of physical injury. And the person suffers nervous shock as a result of fear for himself or herself, for their personal safety. You have suffered that nervous shock as a result of fear of your personal safety. And that person might have also suffered physical injury. So he might have had physical injury, maybe a broken leg, a broken arm, whatever kind of physical injury. But in addition, has suffered some injury that we have decided to call psychiatric injury, illness, or nervous shock. Then you have the secondary victim. This person is outside the range of foreseeable physical injury. He's not on the road when the vehicle is crashing. He's not in the vehicle. He's not within the range of harm, so to say, from the event that causes the injury. But he suffers reasonably foreseeable psychiatric illness as a result of another's death or injury, when the person has witnessed or come within the proximity, or what we call proximity, of someone's death, of someone's injury, or fear of injury to another person. Then you are talking about a secondary victim. So secondary victim is not within the range of foreseeable physical injury, but has still suffered this same form of recognizable psychiatric illness: a stroke, a miscarriage, a heart attack, a PTSD, and whatever. The rules of engagement regarding each kind of victim differs. So we've said the injury must be recognizable psychiatric illness and evidence will be needed. The person that suffered the injury can be a primary victim or a secondary victim. And the injury can be concomitant to physical injury. That is, can be premised on the fact that somebody has suffered a physical injury, or it can stand alone psychiatric illness. It may just be that it almost happened, but it did not happen, so to say. the initial rule was that there's no liability for nervous shock. Again, we are talking about the floodgates argument. We've talked about it before. There was no liability for nervous shock because the law talked about the difficulty. How do we know it? You have suffered this nervous shock. Don't forget that even the state of medical development and was not as it is now. How do you diagnose the cases, the injuries? How do we determine the value to place on that injury? When you're talking about property damage, you can evaluate the property. When you're talking about personal injury, you can look at the cost of treatment and whatever. But PTSD and all these kinds of injury, how do you put monetary value on emotional injury, emotional loss? Then there's the floodgates argument. So if we take the case scenario that I presented before you, and you say so this accident happens, we see it every day in the streets. Some will even park their car to watch an accident that is seen on the road, a train crash, a plane crash. Sometimes you watch it on YouTube, you watch it on telly during the news, you listen to the events on radio. A lot of the times, so many people will be involved. You have the victims of the accident, you have even the person that is negligent. Of course, we are assuming that you have been the defendant has been negligent, because this case scenario is trying to determine duty of care with regards to negligence. So you would have the people that are helping to rescue, to attend to the patient, maybe medical personnel, they can be police, they can be road safety, they can be anybody that is involved in the rescue. Don't forget what we talked about, liability of duty to rescue and what have you. Whether there's a duty to rescue, we've treated that in the past. So it can be bystanders. You're just standing by and watching. You didn't participate in anything. You didn't attempt to rescue. You're not a victim. It can be relations that heard about it and ran to the scene of the accident, or ran to the they saw it happen, or they saw the aftermath when the victims were still on the floor, or when they have been carried to the hospital and they met them in the hospital and they are being treated. It can be relations, and it can be friends, it can be colleagues at work. So there can be so many people, and then all these people now come forward to the law, before the law, and say they had suffered nervous shock or psychiatric illness. How do we count? When will the litigation end? In the borderless world of the internet, someone that might have watched that in live on YouTube, they might have watched it, a recorded version of it. They can listen to it. You can send it by WhatsApp. We see people forwarding messages, all sorts of messages on using technology. So can we say, if all the people that receive this information, this video, this recording, suffer PTSD, suffer nervous shock or psychiatric illness, you can imagine how many people can have a cause of action in law. So that's the floodgates argument. The law therefore realized that, of course, it's reasonably foreseeable that if someone watches a video of extreme human suffering arising as a result of accident, that they are going to be affected. They may even have PTSD. It may not be the whole world that will have it, but some people may have it. So it is reasonably foreseeable that when someone witnesses an event like that, as human beings, they can be affected. So the law realized that reasonable foreseeability cannot be the only test for liability for psychiatric illness or nervous shock. Something else beyond that has to come into play to stem the floodgates possibility. So, and the law therefore created streams of liability and said that, of course, you must have foreseen some injury, whether physical or psychiatric, for you to be saying there's a duty of care. Defendant must have foreseen some form of injury, physical or psychiatric. But the law was that there's no liability for nervous shock where there is nervous shock as a result of fear for the personal safety of another person. Okay, if you are not within the range of foreseeable injury and you are not a primary victim, there will be no liability. There will be no duty of care by the defendant towards you as a plaintiff. So the evolution of the law and the stages of liability is what we now look at. The law first said, when the cases began to come to the courts, the law first recognized that liability for nervous shock would arise where you have a fear for your safety or the safety of your parents or a child or a spouse. You are just in a car, you're going to the shopping mall to shop for something, and suddenly you left your children in the car, or your mom in the car, your injured mom, and then suddenly you had a loud bang, and they say, a woman has just been, a woman was sitting in a car and has just been crushed, and you heard that bang, that sound of the accident, and the person is so shocked. I mean, just had already imagined what has happened to their mom or to their child, and they just go into shock, and they are unable to recover. This kind of an incident, the law first accepted and said, okay, if there is liability, there could be liability or there could be duty of care. Let's put it that way. There is duty of care when the person that suffered the injury feared for their own safety, or safety of a parent, of a loved one, so to say. Then the second stage of the liability was that duty of care would arise in favor of persons who are within the sight and sound of the accident or come upon the immediate aftermath. Those cases, McLoin and O'Brien, Hambrook and Stoke Brothers, and all those kinds of cases were cases that concern situations where the claimant was told that there has been an accident and quickly ran to the scene of the accident, met the relations in this state that the accident produced. They were still on the floor at the emergency or the hospital, and they were in blood, and they are trying to sort them out, and they saw the immediate aftermath of the accident. So some of them were within the range of the accident. They had it with their ears, or they saw it with their eyes, or they came in within the immediate aftermath of the accident. And I want you to pay attention to McLoin and O'Brien and Stokes for that understanding. And then eventually, the fundamental rules emerged in what they call the Hillsborough litigation, where the law was stated that liability arises where it is reasonably foreseeable that a negligent act will produce nervous shock in a person of ordinary psychological resilience. And when we say Hillsborough litigation or cases, you have cases like Jones and White, then Halcock against Chief Constable of South Yorkshire. Now, what is this basis of liability in the Hillsborough litigation? Let's look at the case a bit. It was a case that concerned about 95 claimants, about some claimants that were claiming that they had suffered nervous shock or psychiatric illness as a result of the accident that happened in England during a football match between involving Liverpool Football Club. And they suffered that injury because the Hillsborough stadium that was used was overcrowded. The police had let in more people than the stadium could take, and there was a stampede at the stadium while the match was going on live. And you can imagine a typical football game. People were at the stadium watching it. People were watching on television, live television. Radio broadcast was taking place in those days. And internet was not such a common thing, if it was even in place then. And then, so when the stampede was taking place and people were seeing human beings being crushed to death, trying to survive and struggling, live broadcast. Some people were outside the stadium. They were watching on TV screens. Outside the stadium, could not go in. So you have about a sort of claimants. There were many litigations coming out of it. Imagine how many people are in a stadium. We are talking about floodgates. So they consolidated all the cases and brought them into one direction. So you have cases like Jones and White and Halcock against Chief Constable of South Yorkshire Police Station. That some of the consolidated cases. And these claimants involve people that were forced some that were in the stadium, that were within the range of injury. So those are primary victims. Some of the people that were in the stadium who escaped, who were either physically injured or were not physically injured, but claimed they suffered psychiatric illness. Some were outside, those who watch on television screens outside the stadium, were not inside, but were outside. Some were watching on television when they saw the incident happening. Some were listening on radio. You will have claims by those who participated in the rescue, police officers who participated in the rescue, who suffered because of the extremity of human agony and human suffering, and you are watching people dead. Some were watching on their TV screens at home, and they knew their relations had gone to the stadium. Their brother, their cousin, their child and son had gone to the stadium to watch the match. And so when they were watching that incident on live TV broadcast, some of them claimed that they suffered psychiatric illness or nervous shock. So the court, by the time we got to that point, Alcock and Chief constable of South Yorkshire Police Station, the law was formulated. The law did not say again that, okay, you cannot come as it was initially done, that, look, we have issues with liability for nervous shock. At that point now, the law they now laid down the rules and said, look, there can be liability to a secondary victim. If you are a primary victim, you are the one that was injured, or you are the one that was within the range of foreseeable injury, reasonable foreseeability alone is sufficient as a basis of liability for nervous shock. So those who were victims, who were either injured, were in the stadium, for instance, they are primary victims. They are within the range of foreseeable injury. So when they suffered all these things that we call psychiatric illness or nervous shock, all that you need is to say, was this reasonably foreseeable? And we have emphasized that rule in, remember, Donoghue and Stevenson that we talked about. Well, that is the rule. If they are within, if it's reasonably foreseeable that someone that is a primary victim who suffered nervous shock, of course they'll be liable, and that is the end of the inquiry. But when you are talking of secondary victims that are not within the range of foreseeable physical injury, those who are watching on television, those who are watching on YouTube, those who were listening on radio, those who were on the road, they just heard the story from a friend. Did you hear what happened? Have you listened? You know, you were not within the range of injury, so to say. This kind of victims, we have said, are secondary victims. The law said that, look, for you to claim lab and successfully show proximity, and the ability, a duty of care is owed to you by the negligent defendant, there must be a relational proximity, what we call dearness, what we call love and affection. Who are the primary victims? Do you know them, or you are just a busybody? You don't have a relation in the stadium, you don't have a relation on the road, that on the vehicle that caused the accident. You are not, you are, you know. So they say there must be a relationship of, there's a relationship of love and affection. It's not even sufficient to come to court and say that person that was a victim is my cousin. Yeah, family, but do you have a relationship that the law has called love and affection? In our course case, the law was able to look at it and say, look, you can presume that a parent loves the child. So if you come as a secondary victim, a mother is told that your son has just been involved in a plane crash, or has just been crushed to death, you know, by a car, or has been involved, not even dead, but just an accident has happened, you know, and that's, the law is ready to presume that parents have love and affection, parents and children between each other, they love each other. So when they hear that news, it is reasonably foreseeable that they could suffer some form of psychiatric illness. But the law is not going to presume that every member of your family, that you love them and you're affectionate towards them. And it says, if you are brothers, for instance, you must establish before us that there is love and affection between you and that your brother that has been a primary victim, over whom you say you have not suffered psychiatric illness or nervous shock. And how do you show? And you know, English law is very interesting. It's great reference. If you go and look, so that's why I encourage you to read your cases. If possible, read them from law reports and read thorough, especially when they are lupus classicals like Alcock's case that we are talking about. It says, in that case, the judge said, look, there are degrees of brotherly love. There's the love between Cain and Abel, and there's the brotherly love between David and Jonathan. Cain and Abel were people in the Bible. They were biological brothers. They were the only children of their parents. And Cain did what? He killed Abel out of jealousy. He killed Abel. So if Cain and Abel are before the law court today, Cain might want to come and say, hey, because Abel was injured in that accident, then I suffered psychiatric illness. He has to prove that he loved Abel and had affection. And in that story, we know that Cain did not love Abel or was affectionate towards him. And that's why he killed him. So it's not going to be presumed that because you have family, you have love and affection. And he used the other example, say, and there's that brotherly love between David and Jonathan. So somebody may have love and affection and they are not family. They're not family. Like Jonathan, at the expense of his relationship with his father, loved David until he died. So there must be a what we call dearness, nearness, and nearness. You must have some dear relationship with the person. That's the first rule. Then locational proximity. Are you proximate to the accident or to the event or the immediate aftermath? Proximity in time and space. Were you there at the scene and you saw it with your own unaided senses? Or you came upon the incident just after it happened? Sometimes you are driving on the road and you are not there when the accident happened, and you saw people on the floor dead or in agony, in injury. You were not there, but you came upon the accident. Maybe you are in the next vehicle that came there, or the 10th vehicle. You met them in the state that the accident has rendered them to be in the accidented state, so to say. In that case, you say, okay, you are proximate to the accident. You are not someone that just was in your house and someone say, come and see this video I recorded, and just watch it on your phone. Or you say it's on YouTube, go and watch it. So yeah, we are not talking about people like that. You must be near to the accident, you must be proximate to it. There's a closeness you must have to the event or its immediate aftermath. So busybodies are not what we are talking about. You're just going to be watching any kind of horrific event. Say, go and watch it on YouTube and you will see it. And then you see after you have watched it, you chose to watch it, then you come and sue the negligent person. If you do that, you know that it's going to be liable for everybody in this world. People that do not even suffer it will not claim that they suffered psychiatric illness. They talk about temporary proximity. You perceive the accident, like I said, by your unaided senses. It's not sufficient to say, I watched it on television, I watch it on radio, I listen to it on radio, I watch it on YouTube. No, we say there must be that spatial proximity. There must be, the proximity of watching it directly by your unaided senses. So that means that what? You are there at the scene, or you came upon the scene. The law as else, for instance, when it comes to temporal proximity, that, well, if either you are physically present, or you at the scene of the event, of the incident, or you came upon its immediate aftermath, or you are able to have direct contact emotionally with the incident that we are talking about. But even though watching on television, watching on radio, on YouTube, or on whatever will be regarded as not being proximate to the incident, it has been recognized that where the thing is being streamed live, that the live streaming has removed the barricade of a screen, because then you are not prepared, you are shocked into watching an event live. Sometimes you have seen things like that, someone dies live. Sometimes there are situations where say they are recording a film and it's the live recording. Imagine someone going to shop. Today, every one of us is on the phone. And person say, hey, hi, I'm on the road. I'm in uni. I'm in uni now. I'm a student of this university. I want to show you the scenes, beautiful scenes of the university. It is today you have also social media platforms that you can do that. As the person is saying, okay, I'm on this cliff. This is a beautiful scene that where people take nice pictures. And as the person is doing the recording live, and all of you are watching on whatever device or app that the person is using, and he or she wasn't looking there and just falls off the cliff, and it's a live recording. In such situations, the law is prepared to hold that there is still proximity, because it's a live broadcast. It's a live broadcast. So ordinarily, watching from a screen, through any device, will not show that you are proximate to the accident or the immediate aftermath. But because it's a live broadcast, you will be able to, the law is prepared to say, okay, in such situations, there is some form of proximity. These are the basic rules that stemmed from Halbach's Alcock and Chief Constable of South Yorkshire. Don't forget what I always say. We are here to espouse the law to you. We expect that you are able to sit back and read these cases, because we cannot do that, take all the cases in the course of the presentation. The summary of what we are saying, therefore, is that now the ability for nervous shock raises different questions when you want to formulate the duty of care, whether somebody holds a duty of care. The law could not just premise it on reasonable foreseeability that has been laid down as basis of liability for personal injury. And the reasons for this have been evaluated and stated. The essential thing is that the floodgates argument that we have always emphasized. Then later, the law began to oppose liability in stages. First, it separated victims into primary and secondary victims. While primary victims who suffer nervous shock as a result of what happened to them personally or about to happen to them could claim using reasonable foreseeability. Secondary victims are unable to claim using reasonable foreseeability. And the secondary victim must meet the control mechanisms that has been laid down in the case of Alcock against Chief Constable of South Yorkshire Police Station. They must meet those mechanisms. It must be, I can shorten them and say nearness, dearness, and dearness, love and affection, nearness, proximity to the place, and nearness. That's how a judge has described it. So there must be love and affection between you and the primary victim, between the secondary victim and the primary victim, and that must be established in most cases, unless the ones that the law is ready to presume. You must be close to the scene of the accident or the immediate aftermath of the accident. You must have perceived the accident by your own aided senses. You must have either seen the accident itself or heard it by your own aided senses. By saying unaided senses, you are physically present. Or if you are not physically present and your senses are aided, maybe it's a live broadcast of the accident. And the victim must suffer what we call recognizable psychiatric illness. So it's not just to say, oh, I was distressed, I was alarmed. No, it's not sufficient to say that. Then liability, therefore, is relational, locational, and temporal proximity. A secondary victim must have a relationship that we have talked about. Dearness. There must be some measure of love and affection. It must come within the sight of the accident, sound of the accident, or immediate aftermath of the accident, close to the accident in time and space. You'll be hearing that phrase or reading it in a lot of text, close to the accident in time and space. Okay, not that 10 hours after the accident you went to the scene and saw fragments of the vehicle or the train, and you are watching and recording and say, if people could have been in this thing, this is traumatic. No, you are not within the accident in time and space. Then you must have received the accident with unaided senses, perceived it with unaided senses. What I mean by unaided senses? That's what we summarize as hearness. Not hearsay from a third party, not somebody telling you, or not watching through a screen or any kind of device, but through your unaided senses, except of course it can be said that it was a live broadcast. And that represents the basic formulation of duty of care for nervous shock, or what we call psychiatric illness. What we are still doing is to try and find out, when you have a case scenario that shows someone has suffered this kind of illness, what do you use to prove duty of care? You're not going to say it is reasonably foreseeable if there is an accident or an event that causes so much human suffering, anybody that sees it will also be traumatized. If you just argue like that, then you do not understand the limitations of the reasonable foreseeability test. You must go further and say, let me look at the Hallmark mechanisms and see whether this person has met the mechanisms. These mechanisms has to reduce the floodgate litigation. But as the person met these mechanisms, if the person has met these mechanisms, then I can say there is a basis for liability for nervous shock or psychiatric illness. So I'll see you at the next presentation, where we'll be talking further, about components of the tort of negligence. And I hope that by the time you are writing your examinations, you are able to appreciate how duty of care is formulated with respect to different kinds of issues in law. Today's own has emphasized where they have a case scenario that deals with someone claiming recognizable psychiatric illness or nervous shock. You must make sure that you identify the kind of claim, then the victim. Is it a primary victim or a secondary victim? If it's a primary victim, you know that the rules relate to reasonable foreseeability. If it's a secondary victim, then the rules relate, they go beyond reasonable foreseeability to find another form of proximity, and that this is established in the case of Hallmark against Chief Constable of South Yorkshire Police Station. The various dimensions of this duty of care can be found in the cases that you saw in the slide presentation. Have a good day ahead. Thank you.